Hello everyone and welcome to today's Mondac webinar in association with BTG Advaya, who will be discussing the data privacy landscape. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Vikram Jeet Singh is a partner in BTG's New Delhi offices, heading their Tech, Media and Comms TMC practice group. He has almost 20 years of experience in advising Indian and overseas clients on complex issues relating to digital business, data privacy, platform liability, and online selling. Vikram's areas of expertise include advising on data protection and privacy regulations, cybersecurity, internet intermediary regulations, online content, payments and fintech, and online advising matters. Ayan Sharma leads the policy and advocacy in the TMC practice group at BTG Advaya. Ayan has worked and engaged in extensive advisory and legislative drafting for several central government ministries, specifically in the field of information communication technologies and digital markets. His advisory work extends to leading domestic and international content platforms, online gaming entities, online travel aggregators, and social media platforms on regulatory and policy matters. Fleming Moose is specialized in data protection and IT law and has spent many years advising national and international companies from the technology industry as well as their customers. Fleming advises his clients on the entire range of data protection law. He also focuses on designing and negotiating all kinds of contracts related to data protection, and he is regularly involved in outsourcing projects, large IT projects, and IT law disputes. Gauri Manglik is a senior business attorney based in Menlo Park, CA, with a strong background in providing strategic, legal, and privacy counsel to technology companies. She is currently the Deputy General Counsel, Privacy and Product at GoFundMe. Her experience spans various roles, including serving as General Counsel and Chief Privacy Officer at Clearbit, Deputy GC at Aura, led the AI task force at SoftBank, and she also founded and led KitabWorld.com, a mission-driven e-commerce startup. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we'll endeavour to answer as many of those questions as possible. It's now my pleasure to hand you over to our panel to begin. Thank you.
Thank you, Dan, and thank you to Mondac for organizing this webinar. Thank you also to my fellow panelists who are giving their time for this interesting discussion that we want to have on data privacy laws today. My name is Vikram and I'm a partner with BTG Advaya, and I have been advising on privacy related matters for almost a decade, mostly to Indian and overseas clients. We'll spend about an hour today together on this webinar speaking about India's new Digital Personal Data Protection Act. We have a very good panel with practitioners from the European Union and as well as the US who have deep experience in data privacy. So what we will do is we'll ask them as many questions as possible. We'll make this as interactive as possible. Let us start off by taking a brief look at the basics of India's new data law and looking at its history and essentially giving you a flavor of what the new law contains and where do we expect it to go in the next few weeks and months. Then we'll go on to the panel who will pitch in with their experience about other data protection laws and how do they see in their experience India's data protection law evolving. We have a slide deck here that we'll be sharing, but we won't go through every slide. We'll of course send you the slide deck and any of the materials that we use in this webinar by email later on. Like Dan mentioned, please do send us your questions in the chat utility, or you can email any of the participants after the webinar and we'll be happy to take it up with you. Let's go to the next slide and let's start with the history of the data protection law. And I want to make a very brief point about why does the Indian data protection law look like as it does and what is the history behind it. So India has actually opted for a fairly short data protection law. It's only about 30 odd pages and about 40 odd sections. It's actually much smaller than GDPR for one. Historically, India's regulators, India's parliament did try and see if a GDPR similar, if a GDPR-like law will work in India, but they were not successful. And therefore, the law that we have in front of us in India is a fairly simplified version. Historically, this all started about 5-6 years ago when India's Supreme Court ruled in a judgment that informational privacy is a facet of a fundamental right to life of all persons, of all individuals, not just citizens. And in 2017, the Indian Supreme Court required the Indian Parliament to enact a specific data protection law. The first draft that we got in 2019 actually was pretty much a GDPR copy. But when this was taken to the civil society and businesses for comments, this proved to be too cumbersome, maybe a bit too finicky for a big country like India. And this was withdrawn last year. Now, the law that we have in front of us, which was passed by the Indian Parliament in August of this year, is, to my mind, quite similar to the Singapore Data Protection Act of 2012. So we have essentially gone back a little bit, that that India's parliament and regulators have realized that they need to have a more simplified, maybe a more principle-based regulation, as opposed to a more detailed one like GDPR, because a principle-based regulation probably works best for a country like India with varying data protection needs. Because the Indian law is principle based and quite short, a lot of meat in the regulation is still to be decided. What we expect to happen in the next weeks or months is that the Indian government will come up with draft rules for operationalizing the Data Protection Act of 2023. And after the draft rules have been discussed in the public, they will operationalize the act. To be clear, currently the Data Protection Act, the new one, is not in force as yet. It has been passed by the parliament, but it's awaiting that nod of the central government to come into force. We think that should happen during December of this year, if not early next year, pending rules being formulated. Let's go to the next slide. And there are, like I mentioned, the new Indian law follows a principle-based approach, and these are the various principles that you can look at, at your leisure. We'll send this to you. This will sound similar to somebody who has, maybe worked in GDPR or CCPA before in terms of, the purpose of data collection, data minimization, data retention and protection. They are similar attributes. They are similar goals that the Indian regulator has in mind. Having said that, the Indian law is still a fairly big paradigm shift, and we'll go to the next slide. And we'll discuss very briefly why the new Indian law is a paradigm shift, and frankly, why are all of us here today on this webinar. Until now, India's privacy law has been on the books. There is actually about 12 years old data privacy rules from 2011, which have been on the books for about 12 years, but they were never regulated. Now the expectation is that the new data privacy law will lead to a data protection authority being constituted, and it will actually lead to enforcement. One of the most important aspects of the new data protection law in India is on the last page, which is the penalties that have been prescribed. So I think we all, heaved a sigh of relief when the data protection law was passed, because thankfully there are no criminal penalties, and the Indian law also does not have the 4% of GDPR or revenue concept from GDPR. Having said that, the penalties in the Indian law are still quite extensive and quite heavy. They can go into the millions of dollars per breach. So I think it's very much a case that for the first time in pretty much all of our for the first time ever, India will have a data protection law which has robust provisions for breaches and non-compliance being punished, and it would also have a bespoke data regulator whose sole job will be to enforce this law. Which is why we think this is a paradigm shift in how data privacy has been done in India so far, and I think this will change quite a bit going forward. There are some other aspects that we have mentioned here, and I'll ask Ayan, my colleague, to maybe touch upon a few more of these headline items from this law and the presentation over the next 10 minutes. But I think there are, while quite a bit of this law continues the trend from the last version of the law in that it still is a consent-based regulation. It still has some exemptions provided for IT services and similar. At the same time, in many instances, this law sort of marks a departure from how data privacy has been practiced in India so far. Ayan, if you can maybe take over the next couple of slides.
Yeah, thanks, Vikram, for the introduction. Thank you to Mondak and all the panelists for being a part of this. Just as a brief introduction, I was part of a team that was actively drafting and advising the government on making the DPDPA and the upcoming Digital India Act. So if none of you like the act, you know who to blame. But there is, so essentially we need to start in terms of the what, who, and where also. Just like the GDPR, it applies to the data processed within India. It does not apply to Indian citizens' data being processed outside of India, as earlier iterations had sought to do, and as the GDPR also does to a large extent. If you go through these 3 points pretty quickly, is that it is only such personal data which is in connection with the offering of goods and services to data principals within India. So the data principal does not have to be an Indian citizen. It could also be a foreign citizen. It is an individual specific act. A foreign citizen living in India would also get the benefits of the Personal Data Protection Act in India. In its material scope, it applies to personal data that is collected in digital form and in non-digital form, but subsequently digitized. This is actually quite interesting because the DPDP Act has done away with ambiguous words such as online data and offline data. It has just said digital personal data and data that might be digitized subsequently. It does not apply to non-digital data. It applies to data process for. It does not apply to data process for personal or domestic purposes. This would be your in terms of your employment-based data, in terms of people who might be working for you at home, or even your drivers or etc. that your company might employ as well. And thereafter, there's data made available by a data principal under a legal obligation, which is, I mean, the legal and rightful obligation exemption applies to all. The categories of data which will not be covered by the DPDPA have been substantially narrowed in the present act. If you go through, once you go through the materials that we share with you, you will see that it's a very narrow list of things that are exempt. Could we go to the next slide, please? This is, I think, what most people are interested in. These are the obligations on the data fiduciaries. As Vikram earlier explained, that they have to obtain consent for data processing, which is the basic principle across the world. The main thing here is the setting up of grievance redressal mechanisms, which to a large extent is what industry is also talking about in India, because they're not sure in terms of what is an effective grievance redressal mechanism, and nor has the government come out with rules that explain exactly what they want in terms of this. What are the various specific distinct features that they would want in terms of a redressal mechanism? They have to ensure accuracy and completeness, and particularly if this data is being shared with third parties or data processors, because this act actually allows you to share an individual's data with a data processor, but subject to contract, just like the GDPR. They also have to delete the data of principals when the data principal has withdrawn consent or if the specified purpose has not been served. It doesn't mean that the time for satisfying the purpose is gone. It means that the data fiduciary has to also have decide if the specified purpose is something that they are about to do or not, which is, again, it's based on the wording of the act, which is slightly, in my opinion, weird. The data fiduciaries, while obtaining consent, have to notify the data principal, he or her, of the type of person. This is again a notice and consent regime. We don't have to get into exactly what they have to do. But the details of the way the data principals may exercise their rights to withdraw consent, etc., is an interesting facet, I would think, because that's particularly new. I think it'll more, again, because most data fiduciaries might do it as a pop-up or a click, a wrap click thing, which again will be difficult for people to go through. It has moved away from the deemed consent framing of non-consent based processing of data. The wording in the act is extremely long if you go through the sections in terms of how they will say that the consent is being given. Sometimes the act has given illustrations as well. So it means if you're continuously using the service and you go in from one facet of the service to another willingly and you purchase it willingly, they don't want to call it deemed consent, but the data processor would not have to take your consent again and again for data that it already has. The last thing is that it now as I explained earlier in the earlier slide, there is a narrow list of legitimate uses, which includes employment purposes, safety measures during disasters, or enforcing judgments or decrees of courts and tribunals. We can go to the next slide, please. I'll run through these very quickly because these are the same thing. The main thing here would be the implementing technical and organizational measures and reasonable security safeguards to prevent personal data breach. Earlier, these rules and security safeguards were under the information technology rules, but they haven't again explained to industry what are the reasonable safeguards. That is why the rules everyone is waiting for the rules to come out quickly so that they can at least have a consultative process to understand these. Like, these are very nice terms to hear here, but they're slightly ambiguous in what they mean. They are obligated to intimate the data protection board in the event of a personal data breach. They again have to take reasonable security safeguards to protect personal data that is under its control or which is processed by a data processor. So it is in the Indian Act. What is interesting is that to ensure that your data processor has the reasonable safeguards or the equivalence concept that the GDPR has, it is up to the data fiduciary to ensure that that happens. It is not the responsibility of the data processor. So the data processor is slightly protected because India, I think, understands that a lot of them would be very nascent industries here, and a lot of them would not know how to comply with these. You will definitely need to, as a data fiduciary in India, whether you're a foreign data fiduciary or a public or a private data fiduciary in India, you will need to have proper erasure and deletion technologies and infrastructures in place. Again, the last thing is they keep using the word effective grievance redressal mechanism. Only the rules will help us understand what is an effective grievance redressal mechanism. Either it is identical to what the data protection board does, or it would be based on existing big tech companies' redressal mechanisms as they are right now. Could we move to the next slide, please? This is I think, a lot in terms of in terms of online gaming, even social media platforms, or even edtech. This is quite important. Is that India is very strict on what happens to children. Like, even in their POSCO or Prevention of Exploitation of Children Acts, etc., they are very, very clear here that you have to obtain verifiable parental consent. They have once again not explained what verifiable parental consent means, but it must, in all likelihood, it would mean a video-based consent being recorded, or an identity-based, or something like that. So your IT systems may need recalibrating to enable verifiable age gating for access, which could be a cost concern for a lot of data fiduciaries. Again, and this also applies to people with disability. And thereafter, they say the concept of a lawful guardian. So you do not know what disability here is. Is it unsoundness of mind? Is it a physical handicap? Is it a mental, is it a learning-based disability, or is it a mentally challenged individual? It's very difficult to understand what disability means here, but they have again given a sort of sweeping section there. And they also say that you cannot undertake processing of data that is likely to cause any detrimental effect on the child's well-being. This again needs to be defined very clearly in the rules as to what this is. And they also don't want you to undertake tracking or behavioral monitoring of children or targeted advertising at children, which I think will continue to happen irrespective of what they might say. So you must have, you should know how and when you store your children's data, and it should be very specifically delineated and denoted in your privacy policies as well as your terms of service. And you must have robust processes in place to deal with breaches and anomalies involving children's data. In fact, from what we hear, even when we attend roundtables with the government or with other think tanks in India or law firms, is that informing data breaches regarding children's data or minor data is far more important than reporting data principles that are above the age of 18, according to this government. Can we move on to the next slide? So a significant data fiduciary, this is the same thing as the gatekeeper concept in the GDPR, where they want, in the Digital Services Act or the Digital Markets Act, where they want certain people to be denoted as significant data fiduciaries. But once again, the authority to do so has been given to the central government. This is not the Data Protection Board does not have the authority to do this. they have basically given you certain factors, and these are not exhaustive factors. These are inclusive. So this list can keep increasing. It's called the volume and sensitivity of data processed, the risk of harm, the risk to rights of data principles, the security of the state, public order, etc. So this will likely increase and would be again once far more better elaborated under the upcoming rules. But they have specific obligations that don't apply to a normal data fiduciary, is that they have to appoint a data protection officer, they have to have independent data audits, they have to undertake periodic data audits, and they have to undertake periodic data protection impact assessments, which I think the tech industry in India is a little scared of this because they don't exactly know how to go about doing this. So once again, consultative processes and processes around this would be quite important. I'd just like to take everyone, can we skip the next 2 slides and go straight to cross-border transfers? Yeah, thanks. So India has it has abandoned the whitelist approach and saying that these are the only countries that you can specifically transfer your data to. They have just said we will notify countries where you cannot transfer data based on certain factors, such as, once again, the security of the state, or even for the rights of the data principle, where they think that they won't be given adequate protection. So there's no hard localization requirement, but they have also said that sectoral specific data localization requirements will continue to apply, such as the RBI payment details. It might have to do with your passport details in terms of people processing your visa, etc. You might have to keep that data in India. Can we skip to the next slide? We can skip this one too. These are exemptions, and data rights and exemptions are similar everywhere. This is the main thing, that they've set up a new data protection board of India. The board will be composed of a chairperson and member who possesses special knowledge and practical experience in the fields of data governance and administration and information technology. Again, a lot of this authority has been given to the central government, so there is definitely a lot of executive oversight on the constitution of the DPB. That it has the power to independently inquire into complaints or intimations of breach and impose monetary penalties. Can we go on to the next slide, please? I mean, we'll share this to you for you to go through this at your own leisure, but this is basically the entire process of how a complaint, appeals, and adjudication will work under the current sections. The next slide, please. This would interest people more. As Vikram said, they are not, I mean, they're not huge, but they are huge. Like, it's weird. Like, it's like per data breach, 250 CR is a massive, like, if you're a small to medium sized company in India, whether you're foreign or Indian, this could like shut you down instantly. So it is strange that they've been given such authority to impose rules, and it's even stranger that you have the exact figure given in the act, but you don't have the rules on how they're going to impose these penalties. The factors that they will consider while imposing this are nature, gravity, and duration of the breach, type and nature of the personal data affected. This is, I mean, Vikram and Fleming and Goria Farsina, they'll be able to elaborate this better, is that this act doesn't distinguish between categories of personal data, but while adjudicating on an entire data breach, they're going to get into types and categories of data, which is, again, it's not my fault that they put this in. There is a repetitive nature to the breach if it has occurred over a consistent time period. Then there is a realization of gain or avoidance of any loss. There is a mitigation effort and timelines and effectiveness. I think this is in favor of the data fiduciary, and the likely impact of the financial penalty, which thankfully means that if it's about to shut you down, they might not put 250 crores on your head. I'll give it back to all the panelists now, because I think we're done. And we can discuss the last 2 slides in terms of what industry must do, etc., and through the questions itself, Vikram.
Yeah, that makes sense. Thanks, Dayan. That's very helpful, and it's a very good insight into the headline items of the DPDP Act. I think what's fairly clear is that 2 things. One is that this is, like I said at the beginning, a principle-based approach. The regulator will be guided by what's in the Act and what the rules that the government will frame around it, but the regulator will have a fair bit of leeway in itself determining, what does or does not constitute good data practice. I think it's also useful, to remember that this law is coming, on the heels of developments all around the world in data privacy, particularly in Europe and the US. We are very lucky to have, Gauri and Fleming with us, who are practitioners of, overseas laws. I think in figuring out how to comply with India's new data privacy law, there's a lot to be learned from, laws that have already come and been for the last 5 years all around the world. Let me maybe start with Gauri. And Gauri, I think, you've done GDPR, CCPA as an in-house counsel as well. From a very basic level, when you look at the new Indian law, do you see points of familiarity, or do you see points of, huge difference from what you've been doing so far?
Yeah, that's a great question. So it's quite interesting. Like on the face of it, I feel like many of these laws seem very similar, right? Like it's principles, it's the same sort of principles, but I really think the devil lies in the details, and you really have to dig deeper to see the nuances and then assess how they would apply to you. So I'll like cover maybe about 5 or 6 points of across the 3 GDPR, CCPA, and the Indian law. Like for example, applicability. I know Ayan touched on this. It sounds like CCPA, it only applies to California residents, and there's also a threshold, like that you have to have X amount of revenue to be required to comply with CCPA. So the benefit of that is that a lot of startups which are nascent and don't actually have the resources to comply, they are exempt until they get to like 25 million in revenue or 50,000 residents data. GDPR too, like a lot of US companies actually can say that they're not actively targeting EU citizens, and so they don't sometimes have to comply. Like there's questions about how much they have to comply with GDPR. Of course, if they're actually getting data of EU citizens and residents, then it becomes important. But in India, it sounds like it's much broader, and so if you're getting any data of like, if you have any operations in India, like for example, a lot of US companies will have outsourcing, like outsourced consultants or contractors, like, then does that just trigger this for us? That'll be something. I think Ayan touched on the types of data. I wouldn't go too much into it, but one of the nuances has always been like some data like IP addresses, how you store them can deem them to be PII under CCPA on GDPR. Now that's not very clear right now in terms of like, what will IP addresses also be PII, or is it just the more standard things like name and address and all of the usual stuff? Consent to me is a very interesting one, because there's a large sort of volume, right, of debate in the US where people don't always rely on consent for processing. And even under the GDPR, there's other ways, right? Like you can do legitimate basis and you can rely on legitimate basis. So when Ayan and Vikram, you were speaking, I'm really interested in figuring out this consent piece, because the reality is a vast majority of processing, especially that is done by data brokers, is not based on consent. It is data that is being bought or transferred from other ways. And so I think that could be a big hindrance for some of the industry. Children is another interesting one. I believe that Indian law defines children as anyone under the age of 18, which is going to be quite different, because until now, COPPA in the US basically has specific requirements for children under the age of 13. So a lot of times, like the verifiable parent consent and requirements that we take care of are only done for children under the age of 13, and GDPR has the age of 16 threshold. So it's interesting now that like there's going to be 3 different thresholds and how extending the compliance requirements there. The last I would say is data breaches. It sounds like there's a much more onerous requirement to report data breaches, which is 6 hours of becoming aware of a data breach. In the US, data breach laws are actually statewide right now, based on states. So there's no federal data breach law, but I know in the under GDPR, mostly the requirements end up being between 48 to 72 hours. So if anyone who's had practical experience going through a data breach, like, you're really scrambling and trying to figure out what happened before. So I think, again, there'll be a lot of devil in the details of when you're required to report and what that report will look like.
Yeah, thanks, Gauri. I think, those are, absolutely the points that businesses will, focus on as well, because, these are the points that will determine how they actually handle data and, what their real impact is. Let me maybe bring in, Fleming at this point. And there are a number of industries, Fleming, that, the question that everybody, will ask is that which industry does this new data law impact? And the answer is everyone. But there will be industry-wide impact which will be, maybe similar, maybe different. Give us your, initial views on the new Data Act, and how do you see this translating down to various industries when it comes to India?
Yeah, thank you very much, Vikram. And this is, I think, also really a very relevant question for the businesses in practice. So I think there's one, based on the experience we've made with how businesses internationally are affected by other rules, including the GDPR. I think the most important and the most decisive factor, so to speak, on how the company is affected is the company pursuing some sort of data-driven business model, or is it not? I think that's really the most relevant factor, because if the company does not pursue a data-driven business model, there are bits and pieces always, but I think it's essentially a compliance exercise mainly. So it's really mainly about putting processes in place, probably appointing DPOs, having the paperwork in order. So it's really very much a compliance exercise. But if the business model is really centered around data, compliance really has can have a business impact. This is true across industries, really, because what we've seen in the last years is with the digital transformation happening in so many industries. It's not only the IT industry, it's not only digital services, but it is also healthcare, it's also finance, etc. So maybe I give 3 examples where you can probably see how the GDPR has had an impact on business models which are centered around data, and where we can see what possible implications the new Indian law might have in a similar situation. So the first one is the impact that the laws had, which limits the free international flow of data, in particular on cloud services, right? I've understood that India is a bit different there. It doesn't have this whitelist approach, but this gives more leeway for international transfers. But still, with the EU being that strict, and in particular after the Schrems II ruling, but even before that, where the European Court of Justice twice actually struck down the data deal with the US. This was a huge impediment for internationally operating cloud service providers, right? So this triggered in 2 ways a change of those services. One, it triggered the development of more locally provided services. For example, you take the Microsoft EU Boundary Initiative. So that's basically the solution which intends to keep the data within the EU, so not only at rest, but also when it's processed, for example. So it's a change to the way the service is provided. But this also triggered new technical solutions in order to avoid international data transfers by encrypting the data, not only at rest, but in memory. So we see developments, AWS, for example, you have those new technologies which are called Nitro or Graviton 2, which are essentially technologies to ensure that even when the data is processed in memory, they cannot be read because they're still encrypted in order to be able to transfer those data across borders, even though you don't have an adequate level of protection. So that's one. Another one is, and Gori already mentioned data brokers. That's really a business model under scrutiny currently, I have to say. So in particular, since, as you rightfully stated, they often do not rely on consent and can't rely on consent really, because they collect data from the public or from various sources. And since under the GDPR at least, the legitimate interest grounds for processing is interpreted rather restrictively, they are under a massive burden currently to really justify those data collections and the data sharing, which they've done so far. We have a couple of proceedings pending for the European Court of Justice, currently in the Schufa case, for example, where actually the whole business model is at stake, you could say. And the third one, really a very recent and popular one, Meta and Facebook. So wherever you have based or you employ a business model where you actually get data as an exchange for the service, so it's not a paid service, but it's financed by advertising revenues. So you all know that after the verdict in the Meta case, Meta and Facebook are now planning to change the legal basis. Currently, they have relied on the agreement they have with the users to use the data essentially for personalized content advertising, and now they're seeking to implement an pay or okay model. So you see, this is really a massive impact on the business model. So whenever data is really at the core of the business, that's really the main differentiator, I would say.
I think that's a very valid point, Fleming, because even though the law, the new Indian law applies across the board, it applies to everyone. It applies to even law firms in India like us. But the targeting, and this will be a targeted law. All laws are in some way or form targeted. Very much the target of regulation, what the government wants to achieve in India is to bring a lot of the data market in some sort of a semblance of order, because given the amount of data Indians generate, there really isn't any framework for they're actually protected. So I think it's definitely the case, as happened in the EU, that the more egregious data uses, the more widespread data practices of big companies will be targeted first, and this will slowly trickle down to businesses who are for example mostly collecting data of employees, who are not really B2C facing. B2B businesses actually might have, in practical terms, a little bit more time to get their act together and comply with the new law before B2C businesses. I think very much in terms of who should act in terms of moving towards compliance, to my mind, will be a B2C business more than a B2B business or an IT business, for example. Gauri, let me maybe come back to you at this point about now that we have this law in front of us. It is what it is. There will be we hope in the next month or so a set of rules that will also come out explaining some of the aspects of compliance under this law. But it will, to my mind, not be perfect before it goes into implementation. As somebody who's implemented data practices, as somebody who's actually implemented procedures for compliance, what is the process that you follow, and what is the process that you think in-house counsel should follow for dealing with this law?
Yeah. Yeah, I think we need more playbooks on this because given the number of new laws that are just coming down the pipe, right? Like even in the US, there's now what I think 13 states that'll have privacy laws by next year. So the way I've started to break this down is like in three aspects. It's documentation, systems, processes. And I think starting with your data mapping, like that's the key sort of set of documentation you need to always have and kind of make and almost like review it at least every 6 months or a year, or when you're making any changes to the way you're processing data. So having that data mapping to understand what kinds of data you have, whether you have children's data, whether you don't, if it's any highly regulated or sensitive data, whether you're collecting data through audio, video, etc. Like all of that is really important to keep and track. And then that'll help you enable where additional requirements will come in. And so keeping that first level of documentation, then moving on to systems and processes. I think we will have to evaluate our DSAR processes to see whether they need to be adopted or modified. We will have to look at, whether the existing DPO that we have for Europe can also be then the DPO in India, or does it have to be an Indian person? Because the requirements, depending on what the requirements come out. So appointing the relevant personnel and then figuring out the processes for DSAR, and then also just the vendors, right? Like when you're engaging with your third-party vendors, what is the process for review of their compliance with the Indian law, and adding maybe contractual updates into our contracts with our vendors and to ensure that they are complying also with any applicable requirements. The third piece of this is going to be the preparing or getting ready for these ongoing audits, especially if you're a data fiduciary, is that right? So it's like, what are the additional DPIAs, ongoing audits that we need to do, and maybe coming with that time frame together. I think the one other thing that I will encourage everyone to do, and something that we will have to do pretty early on once this law comes into force, depending on the amount of Indian data that a company has, is talk to our insurance companies, right? Like figure out what the data breach insurance requirements are. Like that is something in the US, at least as in-house counsel, we play a key. We are part of the the team that kind of figures out the cyber data breach insurance, ensuring that you have panel on the lawyer panel. Like if there is a data breach, ensuring that you have your law firms on the panel of lawyers that you can go to, because if and when there's a data breach, the time is really tight. So you got to be able to move really quickly. So I think cyber insurance will also be an interesting thing to see if that develops in India.
That's very interesting, Gauri. And some of these are items, which somebody who's worked in India, even a lawyer like me, will not have dealt with in respect of privacy before now. So it's a little bit of a learning curve for a lot of privacy lawyers, particularly in India.
Yeah.
Fleming, coming to you, as a privacy lawyer who's worked across the world, particularly in the EU jurisdiction, but you also worked with Indian clients, US clients. From a practical perspective, what have you seen are the pitfalls or hurdles that clients have to negotiate? What is the one thing or two things that take a lot of time and effort, and what would you want clients to get started off immediately on the new law?
Yeah, that's a really good question. Before I answer this, I would like to state though that some experiences have also turned out the other way around. So when the GDPR, for example, was enacted, there was a certain expectation what might be the pain points, and some really weren't. So I think also this experience was really interesting. So for example, as some of you may know, the GDPR contains a right to data portability, which was really new, and which essentially said that as a user you can request your service provider to either give you your data or to another company in order to move away with the service to another provider, really, to allow this shift of the provider. And everybody really made up their minds, how do we do it? What type of format shall the data be? Can we do this, etc.? In practice, this is completely irrelevant. So there was really no big disputes, no really masses of users claiming their data. Certainly, some providers have implemented portals where you can take down your data, which made it easier, but it was not really as relevant as it's thought to be. So that might also be an experience. Looking at those pain points, really, I think one which was underestimated at that time and which is still a challenge is complying with the DSARs, so data subject access requests, because they are the right to get access is very broad. There are very narrow exceptions, and you all have very short deadlines, which makes it sometimes really a burden to comply with them. One, because you really have to dig deep into your data to understand where you have data stored about the relevant individual, and since the copy of data must be complete, it's really a tremendous exercise to be able to collect all this data on the spot and deliver it to the user. We've also seen many instances where the user strategically used this right. For example, in dismissal disputes, it's really a current theme where people are dismissed that they lodge a DSAR just to put some burden on the employer. But also we've seen concerted actions where certain interest groups, for example, have made public calls to individuals to lodge DSARs to particular companies. So one of our clients received, due to such a public call, about 5,000 DSARs within 2 weeks. This was a B2B company, so they were not used to handle large amounts of DSARs. So this can happen. So this is really appropriately handling DSARs, getting the process right, understanding where's the data. I think that's really a pain point. We have talked about third country data transfers already, which for many years has also used up much time and effort at various international businesses, because not only you had to conclude all those agreements and also in larger groups of companies put in place framework agreements, etc. But you had to do those transfer impact assessments. I mean, now with the US being considered adequate again by the European Commission, this has gone away a bit, but formally, all the other countries are still there where you don't have an adequacy decision. So it remains an issue to really have those transfer impact assessments in place and be compliant with international transfers more globally. And then probably one last point where I see which is currently really also a pain point for businesses, and Gori, you've already talked about this as well, is data security and avoiding cyber incidents, really. This is because it's not only a legal exercise, it's also a question of data deletions, right? Because in many of those incidents, you currently discover that data is affected which you shouldn't actually have had at that point of time. So, and I know since data deletion is one of the obligations now under the new Indian law, this will certainly be an important aspect of compliance as well, but certainly also being prepared for incidents, like having appropriate technical security in place, but also the incident response framework, the notification framework, the policies, etc. So since cyber incidents become more and more relevant, so I think that's really also for the future a topic to remain over the next month and years.
Thanks, Fleming. I think that's quite useful, and it's always useful to have a punch list of such items, which should be focused on and figured out during your data privacy journey. It's a little bit overwhelming, I know, for a number of clients to just see the law and just see it approaching implementation. But as always, there are some items which you should basically maybe get to before other items. I see that we've only about 10 minutes to go in the webinar, and this is a conversation we can have for a long time. But let me maybe just bring this to a close, maybe with the final question to each of the panelists, and then we'll see if we have maybe time to pick up one question. So Gauri, maybe as part of your final thoughts on the new data privacy law in India, and what has your experience been on implementing data privacy laws throughout. It's also maybe a truism to say that data privacy, we've got a data privacy law in India about 5-6 years after GDPR, after CCPA. So there's definitely a lag between what businesses face in India as opposed to what they're facing all over the world. Your concluding thoughts, and maybe some thoughts on in addition to what's already in the act, what should Indian businesses be on the lookout for in the future? What could become a pain point, for example?
I mean, I think right now, honestly, a lot of focus in California, and Fleming can speak to this for EU, I'm sure as well, has actually switched over from data privacy to AI regulation. And I was at a conference a few months ago where the drafter of the CPRA, the new CPRA regulations, he was present and he spoke, and they were talking about how they have already weaved in this concept of automated decision making into the new CPRA regulations, which go into effect next year. They were supposed to go into effect on July 1st, and then there was a court case, against their effectiveness being such an onerous requirement for businesses, and so now the enforcement has been pushed back to March 29, 2004, I believe. So the new CPRA regulations, they had this concept of automated decision making, which is essentially to say when you're using any machine learning or other system to make a decision that otherwise a human would make, right? And this becomes really relevant in things like recruiting, loan granting, credit checks, especially in the finance HR space. I think it's very relevant, but I'm sure there's a gazillion other decisions that AI is going to replace. And the new rules that the California authorities have, the draft rules actually just got released 2 days ago on this. So this is a very active area, and people are looking again for opt-outs, documenting the processes based on which these decisions would be made, biases, like checking for bias in the systems, what is the data that is actually being used for these decisions, etc. So I think that's where the law is headed in California and broadly in the US, I would suppose. I mean, California generally takes the lead in some of this stuff. So it'll be interesting to see, and I know EU has the AI Act, if Fleming wants to speak to that, but so it'll be interesting to see where that goes and how India follows suit on that regulation. Yeah.
Fleming, same to you?
Yeah, definitely. So the AI will already now, AI is already used in the companies, right? So the companies actually can't wait on the regulator. So we see so many use cases in companies already, and the legal departments have currently questions around how can I use it lawfully, in particular also in compliance with data protection laws. So I think next to the AI regulation as such, we do have also on the data privacy front, really very interesting questions before us, like how can data be used for training AI, for example, but also in relation to the use of the AI, what's the data protection framework? So I think there's also in the overlap with the data protection law a huge or many topics to address. The only other point that I want to make, and I want to be brief because in order to allow some questions, as you might be aware, in the EU, the Commission has launched a data strategy, which looks at commercializing data really, and not only looking at data under the angle of data privacy and protecting personal data, but also trying to enable businesses to generate data, to share data, etc. So next to the AI Act, we do have new laws coming down the pike, which is, for example, the Data Act, the Data Governance Act, and they all seek to improve ways to commercialize data. And there you have a general, yeah, it's hard to match those requirements or those rights which you have with the data protection law, and it will be very interesting to see how this all fits together. I think currently you only have a very broad clause in those acts which says, yeah, and you still have to comply with the GDPR, but what does this mean exactly, right? So I think with more development of data and data commercialization efforts and laws, this will also be an interesting topic for the next month and years, definitely also for India with the large and very important IT and data industry.
Absolutely. I think that's a very valid point. And, I think both Gauri and Fleming, a point is well taken that automated processing will become a part of data privacy compliance, particularly in a country like India. 5,000 requests, are not a very large number when you have a country of 1 billion people, who can potentially send you a request rightly or wrongly. So, having a bot, for example, look at DSRs and, say yes or no to them, that actually might become a fairly big point of contention going forward as well. And I think once again, AI regulation is something that India is lagging the US and the EU on, but it's very much on the anvil, for the future. Maybe if I can just go to Ayan for about just exactly 60 seconds. Ayan, if you can just set out what the expectations are for the rules, and when do we expect the rules to come out and the law to be enacted, and what's the framework around that, and maybe we can, yeah.
The rules should most likely come out before the end of the year, with about the first month or so of January and February, like a month and a half being given for public consultation on 45 days. But it'll also be very interesting in terms of what Fleming and Gauri were also saying, that the Data Protection Act will have to be seen in conjunction with the Digital India Act coming out, the AI regulations that India is talking about. So it won't be a singular thing that would affect the data industry or even the data brokers. It would be going to be a sort of a cascading effect of several acts over the next year, or like 2 years at least, in terms of how that happens. But the rules, at least for the Data Protection Board, should be out soon, is what I can say quite definitely.
That's useful to know. So, I think December will be an eventful month in India, especially, if the rules come out in early December. And we're definitely at that threshold in India, as well, in which most of our IT laws are about 20 years old, and we are looking to essentially, reform or revamp our, laws that govern computer liability, intermediary liability, telecom regulations, interconnectivity, and similar. I think that's a very, that's a appropriate, point to bookend the webinar. I think we've got a couple of minutes, and maybe, I can put the same question to both Fleming and Gauri, because it's I think a question from Vidisha, who's asking about parental consent under the GDPR for people who are under the age of 16. I think this is a very, relevant question, because all of us, who work in India will be faced with the question that, how are you age gating? How are you getting consent for people on the website? For example, how is even BTG Advaya, getting consent for, maybe a law student below the age of 18 who wants to view our website? So maybe Gauri, you first, and then, maybe Fleming can, have the last word.
Yeah, I think the way a lot of US companies technically handle, if you're not in the edtech space, is how you handle this, just to say in the terms of service that, if you're under the age of 16, like, don't use our services, or tell us, confirm that you've gotten consent. We don't like go into unlike the COPPA requirement where you actually have to get the parent's email, you have to email the parent, have them sign things, and then, you know, make sure that that ties to the child. So that's traditionally, it's a much more lower bar, but Fleming, I'd let you speak. Maybe there's some more on like more nuance there for the regulated side. Yeah.
Actually, this is really still a point where there is not really a very good technical solution. In fact, most of the businesses in practice go down the same route and apply the same rationale, which is probably not 100% compliant, because you actually can't exclude someone ignoring the terms of service. Well, I'm only 12, so and all those technical solutions, which they are normally too burdensome, right? So you have those technologies where with the video camera you can use your ID and then have those certificates, but for normal apps or normal web services, this is too complicated, no one will ever use. So this is still a bit of a gray area on the GDPR too, frankly.
So I think this is going to be a pretty onerous requirement for India if it's required for verifiable parent consent for anybody under 18, especially because 13 and above is where a lot of the tech adoption happens also, right? So at least in the US.
Yeah, and you know, this is as much a engineering technical question as it is a legal one, you know, as to how do you actually, you know, have systems, you know, built maybe solely for India, which show this. I wish we could continue this a little bit further and take more questions, but I see we are, you know, already past the hour mark. So let me stop here. What we will do is that, you know, we have a few more questions that we will try and get back to the, you know, questioners separately, and maybe, you know, put up an FAQ on our websites for the questions we've got. But, you know, let me, you know, maybe bring the webinar to a close by thanking Gordian, Fleming, and Ayan for their participation. This has been a very illuminating 1 hour, even for, you know, a privacy lawyer like me. I'm sure we'll have, you know, further opportunities in the future to, you know, discuss India's evolving privacy regime, and also, you know, like we mentioned, the general, you know, progression that you know, we are seeing worldwide in terms of data privacy, AI, and, you know, similar technologies. I'm sure we'll have more opportunities to connect. At this time, a big thank you to all the panelists. Thank you to the attendees as well. And, you know, thanks to Dan and his team at Mondag for organizing this.
Thank you.
Thank you, everyone.
Thank you, Vikram. Thank you to our panelists today. It's been an illuminating hour, as Vikram said. We've really enjoyed it. Thank you to our audience. I wish you all a good day. Goodbye.